Welcome to Module 9, Resolving Issues Between the Parties, Part 1, Introduction. In Module 9, like all of our previous modules, there is new terminology to be aware of and know their definitions. I direct you to your course module for the definitions defined therein. But as a quick review, here is the material, or here is the new terminology. Adjourn. Basically a fancy legal word for postponing or putting it off or moving to a new date. Chambers, in the context of this module, means the type of court that is being conducted. It is not a full trial court, but an area to deal with procedural matters. Hearing, this is the process that occurs with a master and the lawyers when we're dealing with these interim matters. Master, it's a different form of judge, and I will discuss that in a further slide. And a procedural order. It's not the final determination of a matter or the ruling or the judgment that a judge gives at the end of a trial. It doesn't determine who wins or loses, but it does set procedures or set rules in place for parties to move forward to either trial or settlement. Sine die. Here's a Latin term for you. Sine die means to adjourn, so to postpone or put off a matter indefinitely. So we don't have a date that we want to put that to. Interlocutory. Another way to refer to what we're going to call a chambers application. Again, it is a hearing or matter before the court that is not a trial. What are we going to be looking at in this module? What is our focus? Focus is to looking at how parties solve disputes prior to trial but after the statement of claim. Again, like I said earlier, we're not determining who wins or loses the case, but we are going to help parties solve disputes, maybe interpretation of the rules, maybe following the rules, maybe determining who gets custody of property before the trial or settlement happens. And we're going to look at how those disputes are resolved in chambers. Again, it's a court, it's a courtroom, but it's called chambers. Chambers matters usually presided over by a master, but can be done by a judge. And again, I'll get to the difference shortly. This procedure, or these interim matters, are called chambers applications, an interim court application, or an interlocutory application. They're the same thing, regardless of what you call them. So what is the difference between a master and a judge? You see, I've put some main points here on the screen. First of all, who appoints them? Masters are provincially appointed, whereas Queen's Bench judges are federally appointed. Masters only deal with procedural matters, whereas a Queen's Bench judge actually determines who wins or loses. A master's decision is appealed to the Court of Queen's Bench, and a Queen's Bench judge decision is appealed to the Court of Appeal. Don't ever tell a judge that I've said this, but I used to call masters sort of like they're a junior judge. They don't have as big of authority. Again, I would never call a master a junior judge to their face, but that's just one way to think of it. So what are procedural matters? I've kind of referred to a couple in previous slides, but they could be things like form and content of pleadings. Recall a pleading, remember, is something like a statement of claim, statement of defense, third-party claim, counterclaim. So form, talking about what it looks like, and content, the information in it. The conduct of questioning. Perhaps a party isn't doing questioning or isn't answering the undertakings. Remember, we talked about that in one of our last classes. Or somebody is not answering questions at all. Procedural matter can be interim spousal or child support. You'll learn more about this in family law. But interim is while the party's in the process of divorcing or separate, somebody needs money to take care of the children or be able to survive themselves. So there's an award of money that's not permanent, but that'll help in the immediate time being. And preservation of assets during litigation. There's a dispute over who owns what or who gets access to what. A master, through a chambers application, can determine where that property will reside. So, some more examples of procedural matters. Substitutional service. So remember when we can't do our normal methods of service of personal or recorded mail, we might want to do service by Facebook, and we have to go to the court and ask for substitutional service. This is a procedural matter which would be done in chambers with a master. Or dispensing with service, getting rid of service entirely. Default judgment. Recall when the defendant doesn't respond. If you go back to Module 5, the plaintiff can ask for a default judgment. And also requesting records from an individual or organization not a party to the action. So again, could be during the discovery or the questioning phase, and we need some information from someone and they're refusing to give it to us. And selecting an officer for questioning. Perhaps we're suing or being sued by a corporation and we want them to produce a particular person for questioning and they're not complying or doing it voluntarily. We can go to court to ask the masters make a decision or a ruling that a particular person attend questioning. And compelling answers to undertakings. Again, if we go back to the previous module, Module 8, when we talked about questioning, recall undertaking is when we couldn't remember or someone doesn't know the answer to a question and they undertake to provide the answer at a later date.